So hello, everyone. And for those of you just joining us, please do put your name and any affiliation ID information you would like to add in the chat so we can all get a better sense of who's with us. Welcome. We're delighted to have you all with us. My name is Nina Beth Carden. I'm the director of the Maryland Campaign for Environmental Human Rights. Our organization, as most of you know, is dedicated to ensuring that everyone has the right to a healthy and healthful environment by placing that right in the Declaration of Rights of our state constitution, as 7 other states have done. And we're in good company worldwide as well, for the United Nations General Assembly just this past summer passed a resolution 161-0, recognizing environmental health as a fundamental human right. And we are eager to follow their call to help implement that right in our part of the world. I want to recognize our state legislators who are working to make Maryland such a wonderful place and have signed up to join us today. Delegate Julie Palakovich-Carr, Delegate Shanika Henson, Delegate Linda Foley, Delegate Jen Terrassa, and Delegate David Moon. So thank you all for joining us. We are excited about our webinar today, for we have with us 2 speakers from 2 states that have already placed environmental rights in their constitutions. One state is Montana, celebrating its 50th anniversary of that constitutional right, and the other New York, celebrating its 1st. We're eager to learn important lessons from both of them. From Montana, we're honored to have with us Roger Sullivan, senior partner at McGarvey Law and lead counsel of Held v. the State of Montana. And by the way, if Roger or Rebecca, I make any mistakes in your bios, please correct me. But I pulled them off the web, so I'm hoping this is correct. Held v. State of Montana is a current case in which 16 young people from across Montana are claiming that the state, by supporting a fossil fuel-driven energy system, is violating their constitutional rights to a clean and healthful environment. Roger has dedicated his celebrated professional career to 2 objectives: securing justice for Montana's workers and advocating for Montanans' constitutional right to a clean and healthful environment. And Roger was very helpful to us last year as we worked to get an environmental rights amendment passed here in Maryland. And from New York, we're honored to have with us Rebecca Bratspies, law professor at CUNY School of Law, where she teaches property and administrative law, is the founding director of the Center for Urban Environmental Reform, and an internationally recognized expert and activist on environmental justice. And we cannot do justice to the bios of both of those presenters in this short little introduction. So we're going to be putting in the chat some links so you can read more about them. I am also delighted to welcome as our moderator, Johanna Adashek, who is a visiting associate professor and environmental law fellow at George Washington University Law School. Johanna is a graduate of the University of Maryland Carey School of Law. And while she was there, I am proud to say, through their environmental law clinic, she wrote FAQs for us and white papers that help us answer the fundamental questions about environmental rights amendments. So we're thrilled to have Jo be with us again. I want to welcome my moderator, welcome our speakers, welcome to all of you who have joined us. Please remember, if you choose to ask some questions, just jot the questions in the chat and we will try to get to as many of them as possible. And with that, I turn this over, Jo, to you.
Hi there, I hope everyone can hear me. As a yes. We'll start with Roger. Your Environmental Rights Amendment was passed as part of your Constitutional Convention back in 1972. Congratulations, you've just celebrated 50 years. That's amazing. What does your Environmental Rights Amendment say, and what are a few major impacts that it has had over the years?
Yeah, thank you, Jo. I think it is important to contextualize each of these environmental rights amendments. Certainly Montana's is, it has a lot of textual similarities to the New York Environmental Rights Amendment, but it's, I think understanding the history of each is important, especially where in terms of construing and implementing these environmental rights amendments, the courts look to the history here. We have quite a history of our constitutional convention. In fact, my little laptop is propped up at the right height with volumes of the transcripts of the Constitutional Convention. That's how often they need to be cited in terms of argumentation, in terms of particular cases and what they mean. Yes, we celebrated our 50th anniversary this year. On the subject, I had the honor of addressing in the, I don't know if you can see this, probably not because I have a double reflection, but I'm addressing in the Capitol the surviving members of the State Constitutional Convention from 50 years ago, when we recently celebrated them during this year of awareness and appreciation of our Constitution. Montana's 1972 Constitution commences with a covenant between generations of Montanans. It was written by the youngest member of the Constitutional Convention was convened in 1971 by passage of the requisite legislation, enabling legislation of the Montana legislature in 1971. I might add the same year that Pennsylvania passed its environmental rights amendment. And so we convened a constitutional convention in the spring of 1972 that then resulted in a wholesale rewriting of the Montana Constitution. And so I think it's important to contextualize it in that sense. Our environmental rights are part of the fabric of this document that still inspires many. It starts with a preamble, which I will read because the Montana Supreme Court has construed the explicit environmental rights provisions in the context of our preamble. They have said the preamble to the Montana Constitution informs the construction of the explicit environmental rights provisions. And so it starts with a covenant between generations of Montanans. We, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and desiring to improve the quality of life, equality of opportunity, and to secure the blessings of liberty for this and future generations, do ordain and establish this Constitution. And so the specific provisions to which the Montana Supreme Court in subsequent cases has tethered that provision to are in our Declaration of Rights. We have Article 2, Section 3 sets forth our inalienable rights, the first of which is, and I quote, "All persons are born free and have certain inalienable rights. They include the right to a clean and healthful environment," as our first inalienable right. Then in Article 9, which more explicitly addresses the environment and natural resources, Article 9, Section 1, I quote, "The state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations." And so once again, I think it's important to understand the intergenerational compact that we have explicated in the Montana Constitution. It's a matter that I'm litigating at some length with an entity called Our Children's Trust, where we have a case, as Nina indicated in the introduction, that's pending. We go to trial here in June in terms of a fairly lengthy trial in terms of what the meaning of that intergenerational compact is in the context of the climate crisis we're facing here in Montana. So with these provisions in place, I would say that the mechanism through which they were adopted was then a popular vote in November of 1972. And unlike the New York experience that was quite a overwhelming, I think, electoral victory for the amendment of the New York Constitution to add their environmental rights, the entire rewrite of the Constitution was a very close affair. It was something like the cliffhangers in Arizona and Nevada that we're just sorting out in terms of those Senate races. It was very close, but passed and then was challenged on all sorts of procedural grounds in the Montana Supreme Court and survived by a one justice majority to come into effect in 1972. So I think that one of the things that would be maybe helpful in terms of the subsequent history would be understanding that it took a number of years of litigation to really define the particular applications and meanings of these constitutional provisions. So maybe just a little bit of a brief summary of our case law. Really, the first 27 years of the existence of our environmental rights provisions, the courts were, I would say, less than consistent in terms of their construction and implementation of it. It really took a case that was decided by the Montana Supreme Court in 1999 that's entitled Montana Environmental Information Center versus the Montana Department of Environmental Quality to really vivify the full meaning of that. And that particular case involved our Department of Environmental Quality permitting a mine exploration, drilling and pumping of arsenic-laden waters at the headwaters of some of our most famous trout rivers in Montana. And permitting it, notwithstanding the fact that the record indicated that the contamination, including the arsenic contaminated waters, could have a negative impact on both the fishery and potentially on human health. And yet the Department of Environmental Quality had decided that that was within bounds of the risks that they felt were reasonably protective of human health and the environment. So that case went up to the district court, agreed with that. It was kind of like more or less like so many agency decisions with which most of you are probably familiar since we live in the age of administrative governance almost. So the net effect of it was that the district court affirmed the permitting decision and it went up to the Montana Supreme Court, which in a seminal case decided that the regulations that were relied upon by our Department of Environmental Quality in allowing this permitting and drilling to mine drilling to proceed were violative of the constitutional provisions, all three of them. So they kind of read them together, both the Article 2 inalienable right, the Article 9 more explicit environmental provision, and the preamble to the Constitution. And in doing so, they really mined the transcripts of the Constitutional Convention to inform just what it was the intent of the framers of our Constitution in passing these resolutions. And so I think that our jurisprudence, our Montana jurisprudence, really begins in 1999, because it wasn't until that time that we succeeded in finally giving life to these environmental provisions. That may be somewhat instructive in terms of the New York experience. Coming out of the chute, they undoubtedly have more of a strategic plan in mind, but it took us a number of decades. It wasn't for want of trying, but it really took a number of years to more or less educate the judiciary as to.
I think that's a great transition to see what New York did to pass theirs. And if you could for a second, thank you very much.
You're welcome.
Could you tell us about New York's passage? And I will also want to congratulate you briefly on your first anniversary of your Environmental Rights Amendment. And has anything happened since, it's only been a year, but has anything happened since its passage that's notable?
Okay, so hi, everybody. Thanks so much, Roger, for that great introduction as to, based on Montana. Obviously, New York is in a, can you hear me? I couldn't tell if I was unmuted or not. So New York, we're very excited. We are 11 months into having a constitutional amendment that protects our right to a healthy environment. We have a very short and straightforward amendment to our Constitution. Every person shall have the right to clean air and water and a healthful environment, period. That's it. That's the whole thing. Article 19 of the Bill of Rights. So the Bill of Rights includes just what you would expect the Bill of Rights to include: the right to freedom of religion, the right to petition the government, the right to be free from unreasonable search and seizure, etc. That's where this right is positioned in our state constitution. And it's really important that it says each person shall have this right. That means that everybody, not just those who live in the right zip code, not those who have the right complexion, speak with the right accent, have the right education, have enough wealth, everybody, not even citizens, every single person, just by virtue of existing and being in the state of New York, has these rights. It was adopted overwhelmingly, as Roger said. Nearly 70% of New Yorkers voted in favor, a 2-to-1 margin. And we're waiting to see what it's going to do. It's brand new. We're still feeling our way. I can tell you what I know about that's happened so far. I believe I know all of the cases that have been filed, but I'm not quite confident. There could be other things. But this is an invitation for the state of New York to reevaluate the way that we protect our environment, and to consider whether or not existing law, existing regulation, and specific permits issued under existing law and regulations meet that constitutional threshold of every person having a right to clean air, clean water, and a healthy environment. There are 4 cases that I know of so far. I'm just going to tell you them really quickly. Obviously, there are no decisions yet, so we're waiting to see. One, I think is, I'll start with the one that I think is the most interesting and I think is actually the best use of the amendment, and that's Seneca Lake Guardians versus the New York Department of Environmental Conservation. The Department of Environmental Conservation issued a permit for a waste transfer station in Western New York without what, at least the allegation is, without an adequate plan for leachate management. It's going to accept waste that will contain PFAS, and the PFAS will leach into the leachate and be part of the water management system. And wastewater treatment facilities in New York don't have the technology to remove PFAS. And so the contaminants will therefore be entering the local waters. And so there was a challenge brought by, I think, Earth Justice, on behalf of the Seneca Lake Guardians, challenging on a host of administrative grounds the issuance of this permit, saying that it doesn't meet the standards under existing regulation and existing law, and also alleging that it violates the constitutional right to clean water. So that case, I think, raises the question in the clearest fashion, because it is about a hole in a regulatory scheme, because there is no way to manage a waste transfer station's leachate currently in New York law that will not release PFAS into the environment. So this is an invitation, this lawsuit is really an invitation for the state to rethink its process. There are 3 other cases that I know about. One is a challenge to New York Department of Transportation's decision to eliminate a bypass, a highway bypass in Syracuse, and to replace it with a community grid of street level traffic. That decision by the Department of Transportation was motivated by environmental justice concerns. So this is a use based on groups that sort of reject the environmental justice analysis and want the status quo. They're using the amendment to try to challenge a decision that, I at least think is a progressive decision, sort of about making change in the world that better protects the environment and better protects the most vulnerable people. Then there's a case about, it's called Marte versus the City of New York, but everybody calls it the Two Bridges case because it's about a very large development in Chinatown on the Lower East Side of Manhattan. This is a development that has already gone through all of the regulatory steps. It has the approved zoning amendments, and there was a final environmental impact study under SEQR, the State Environmental Quality Review Act. And so the opponents of this project that lost at every step of the way are now bringing a case under the constitutional amendment. And it's sort of a last ditch effort on their part. And, that's not really the place you want to be in. And it certainly is not what I want as the first case interpreting what this constitutional amendment means. And then the case that is furthest along is Fresh Air Fund for East Side versus New York. You can see these are all over the state, right? This one is also outside the city. And it's alleging that the Department of Environmental Conservation has not properly considered odor issues in permitting and overseeing a landfill that accepts waste from the city of New York that is transported out of the city. Again, it's mostly an administrative complaint, but it's also raising a constitutional violation. We'll have to see what happens. I can tell you in the oral arguments for the motion to dismiss the Fresh Air Fund case, the judge seemed to really get what this constitutional amendment does in terms of changing baselines of analysis and really forcing the state to rethink what it views as acceptable environmental impacts on vulnerable communities. So I'm going to stop there because I know you have a lot of questions, and we want to hear from Roger, et cetera. So I got a lot more to say, but go for it.
Thank you very much. That was a great introduction. I think we have a couple more questions to ask, and then we'll get questions from the audience. So let's start with vulnerable populations, like those in disadvantaged communities, and youth populations are often those whose voices are ignored, and at the same time, those most burdened by current and future environmental problems. So I have a two-part question for you both, and I hope you can spend a couple of minutes answering. How can an ERA, an environmental rights amendment, help protect vulnerable populations? And two, how can an environmental rights amendment help governments to better protect the health and environment of their residents? And we'll start with Rebecca and then go to Roger.
Well, when the New York legislature was debating the environmental amendment, which was a step that preceded the overwhelming voter adoption of it, there were two main issues that the legislature saw this amendment addressing. One of which was the problem of emerging contaminants, things like PFAS, where there aren't regulatory standards for the government to enforce. And the other was environmental justice communities that were overburdened by cumulative impacts that the state couldn't, literally see, because the state's decision-making was case by case, project by project, and the state didn't have the legal ability to step back and look at the cumulative impacts on a community. So this amendment was specifically intended to make that happen, to make sure that the way that environmental justice communities or disadvantaged communities, or however you want to say it, the way that they are overburdened is no longer invisible to the state because of the way that state decision-making is structured. And, again, we'll see how it works, but certainly the mood in New York is very optimistic that not only that we're going to have these good decisions coming out of the courts, but that we're going to be able to use this to work with the Department of Environmental Conservation to reimagine the way they're conducting their seeker analysis, to reimagine what matters in permitting, to prioritize more protection of the most vulnerable. And quite frankly, that will not only get us better environmental regulations, permitting, and decision-making, but it also will get us a better environmental and economic culture, because we won't have all of these unaccounted for and uncaptured side effects that diminish the productivity of the state.
Thank you. And Roger?
Yeah, thank you, Rebecca. A particular vulnerable population that has been receiving attention really around the world, and in particular here in Montana, are the youth of our states and various countries. But beyond that, future generations. In other words, what the climate crisis implicates is not more or less the traditional paradigm of environmental contamination of a vulnerable population, but also the children and the grandchildren of that population. So it implicates profound ethical as well as legal questions. And as I mentioned earlier in my opening remarks, interestingly, the Montana Constitution was prescient in that sense, in recognizing explicitly when it came to environmental rights, that these rights were necessarily intergenerational, and that it really was a really important and fundamental, part of the fabric of our Constitution, but also what we have been trying to do in terms of advocating on behalf of the youth of Montana. So in the particular case that was mentioned earlier, where we're representing a cross section of Montana youth from farms and ranch children whose grounds and pasture fields are being ravaged by drought, and to our western wildlands near reservations where the forests are under increasing firestorms in the summer months, all of which are connected scientifically to climate change. And so what we're trying to do is to address that as, vulnerable populations who are actually experiencing specific injury. So, in terms of constitutional jurisprudence, you have to establish standing, and in order to establish standing, you have to establish injury in fact. So we have as our experts this array that has pediatricians who focus on pulmonology and the impacts to the children's lungs, which are really deleterious, not just now, but on a lifelong basis. We have child psychologists that speak of the injury that attends in terms of a psychic sort of impact to their sense of place and their sense of security in the world, their evolving sense of personhood. A little bit taking a page out of the Brown civil rights litigation that was focused on, you'll remember, the impacts to the youth, in terms of advocating for those constitutional rights under the U.S. Constitution. And then, of course, we have the very best scientists that we can find. We have Montana's own Nobel Prize winner, Professor Steve Running, who's one of our experts in terms of the actual on-the-ground impacts. But what we're trying to do is to demonstrate the disproportionate impacts to these youth through our generation's consumption of their future. We are literally consuming the quality of their lives. Of course, not just here in Montana, which we look at as kind of a microcosm, But since we're dealing with global warming, it is, of course, we're a part of this larger process. But we've really attempted to carefully design this lawsuit so that it is not simply the more or less traditional summary judgment administrative record review that most of us are used to in terms of traditional environmental litigation, but we actually are going to trial to prove this as a matter of fact, and therefore to have the statutory scheme in Montana that supports it declared unconstitutional. So we've tethered it, this challenge, to a Energy Policy Act that prioritizes the extraction of our fossil fuels. We have by far the largest coal reserves in America, and we have lots of oil and gas and every other kind of energy you can imagine. So we're saying that Energy Policy Act that prioritizes the extraction and combustion of those fossil fuels. And on the other hand, we have a Montana Environmental Policy Act, similar to NEPA at the federal level, that prohibits the consideration of climate change impacts when the agency is deciding whether or not to permit a proposed coal mine expansion or power plant or what have you. So that's kind of the way that we're addressing this disproportionate impact on this vulnerable population, which is today's youth, and in terms of intergenerational justice, the future. Thank you.
Those were both amazing answers. I assume we'll probably get some more questions about justice a little later, but I think we can move on to a couple questions that often plague the Maryland proposed amendment, and I think this is a good way to answer some common questions that we often get about why we need an amendment and the purpose of amendment and how it works. So specifically, we often hear that an ERA would give courts too much power, or that the courts are the wrong branch of government to determine what violates environmental rights, and that the courts are ill-equipped to remedy cases with environmental problems. How would you both respond to those questions, specifically maybe with examples of your states or your knowledge in environmental rights amendments? And this time we'll start with Roger and then go to Rebecca.
Thank you, Joe. I think that it's important that we contextualize the environmental rights amendments, whether in New York or Pennsylvania or Montana, or the several other states that have some flavor of environmental rights amendments, within the broader system of checks and balances of which our state constitutions and states are a part. The reason I say that was that when I had the opportunity to talk with some of the Maryland legislatures at the invitation of NENA during the last legislative session, it was a concern, Joe, that was expressed. In other words, how does this interface within this whole system of checks and balances? And I think you'll probably hear that concern expressed again when and if, assuming Maryland undertakes the effort anew in the coming legislative sessions or next session. And I would say that, you know, the constitutional jurisprudence in terms of the federal constitution and our state constitutions, as you know, we all know from our civics classes, kind of interfaces on a series of grounds, including, of course, the supremacy clause. And so our state constitutions are always, to some extent, subject to you know, review or certiorari when decisions are made at the state court level. And during the 1980s, there were a series of cases that involved Montana. Interestingly, they were both basically Fifth Amendment, unreasonable search and seizure, and basically came out of this question of when state courts, the Supreme Courts of various states, decide these constitutional challenges to search and seizure or whatever, and they're relying on the state constitution and the federal constitution. Does review lie to the federal, U.S. Supreme Court? And the standard is, well, if there's a adequate and independent state constitutional ground, then it's not really subject to the construction of the U.S. Constitution, if you will. The reason I say that is we in Montana have then had a series of cases that have come down in recent years that do implicate this constitutional right to a clean and healthful environment to some extent. So I'll say this, in the first instance, we have a series of cases that kind of start with the case of Sunburst, the town of Sunburst versus Texaco. Texaco had a refinery near this little town. It contaminated the groundwater, and the town then asserted a claim against ASARCO, both under our standard nuisance and trespass, seeking a remedy of restoration and a violation of the constitutional right to a clean and healthful environment. Montana Supreme Court held that if you have a traditional common law remedy for a environmental contamination, whether it be trespass of the contaminant or nuisance resulting from the contamination, and you can then have this remedy of restoration, it doesn't allow for the assertion of a constitutional claim for a clean and healthful environment. So that kind of has been, that jurisprudential limit has been more or less self-imposed, as courts do, in terms of trying to define bounds as to the practical implementation of a constitutional right to a clean and healthful environment, and how does it interface with our traditional remedies for pollution and cleanup and abatement of those cleanups. And so I've mentioned that in conversation with the legislators, because they're curious to understand the bounds of that, at least based on the Montana experience. And how does that kind of work? Do we have this hyperactive judiciary? And I think not. I think we have because of our judiciaries are challenged with all sorts of cases before it, they're not anxious to develop a new sort of case law if there's already adequate remedies in place. But there so happens that there are instances where there aren't. And a classic example that I mentioned was when we have agencies that are making permitting decisions that are as a matter of administrative record and fact are going to have a deleterious experience. But they're supposedly in compliance with the regulatory framework, the administrative rules. Then, for instance, in the case that I mentioned to you from 1999, MEIC versus Department of Environmental Quality, those regulations were declared unconstitutional. It's kind of an example of where this fits in terms of our jurisprudential tradition that's emerged here in Montana over these last 50 years. And I would say just one other thing is that we have had a series of cases that have gone up to the US Supreme Court as well that implicate in the same kind of contamination circumstances our Superfund laws, our federal CERCLA laws. And we've had the US Supreme Court kind of define some of the bounds for when the Montana right to a restoration of a contaminated site, how does that interface with the federal Superfund laws? So I'll end there, Joe, but just to say that it's a dynamic process wherein the judiciary carefully, has kind of assessed and more or less balanced where it should and can effectively interface with this constitutional right vis-a-vis all of these other existing statutory and common law rules and remedies. Thank you.
Thank you. Thank you very much. Rebecca.
Well, I'm always interested by that question because I think it starts from the wrong place. Rather than being somehow a deviation from our constitutional distribution of powers, this is actually the realization of it. The Constitution itself has a clear process for amendments. And in the New York situation, the New York legislature, in 2 separate sessions with 2 separate supermajorities, voted to add this amendment to the Constitution, which then turns it over to the people of New York to decide whether or not to add this amendment to the Constitution. And the citizens of New York overwhelmingly ratified that. That's the realization of the constitutional process, that the people of New York and the legislature of New York voted overwhelmingly multiple times to add this protection to the state constitution. And while we as lawyers, and maybe as the general public, focus a lot on courts, this is primarily about the executive branch of government, the branch with the duty to take care that the law be faithfully executed. The constitutional amendment, recognizing that everyone has the right to clean air, clean water, and a healthy environment, is a charge to the executive to take care that that be faithfully executed. That means that all of the agencies of the state must make sure that their activities are within constitutional bounds. And I would also add that, courts we turn to courts all the time to interpret concepts that are quite vague. Due process, equal protection, unreasonable search and seizure, cruel and unusual punishment. But we as a society view that as the purview of courts to interpret those concepts. Clean air, clean water, and a healthy environment are way less complicated than cruel and unusual punishment. This is well within the purview of courts. And then I'm going to stop, but I just want to second a couple of things that Roger said. That first of all, courts as a matter of jurisprudence avoid constitutional questions when they can resolve things on other grounds. Actually, I want to say 2 other things. I changed my mind. We've heard this argument before, right? Oh, we can't possibly have courts interpreting what does clean air mean. In fact, the trucking industry made that argument about the Clean Air Act of the United States. Section 109 of the Clean Air Act requires EPA to set standards at a level that are requisite to protect human health with an adequate margin of safety. The American Trucking challenged that, saying this is so vague and ambiguous that you can't possibly have implementation of it. And no less personage than Justice Scalia, writing for a unanimous Supreme Court, said, no, this is not ambiguous. This is the kind of language that we see all the time, that agencies acting under the executive's duty to take care that the law be faithfully executed implement as a matter of routine, and that courts can evaluate without a problem. So, we see this is a go-to attack on all kinds of protections that benefit the public: environmental protection, worker protection, and it's rarely, if ever, has any traction or any validity. And then I'm going to end with one thing. I just wanted to echo another thing that Roger said, is that one of the important things that a constitutional amendment does is that it expands the set of concerns that fall within that duty to take care that the law be faithfully executed, to capture things like emerging contaminants and environmental justice that fall through the existing regulatory cracks. So I'm going to stop there.
Thank you very much. And I hope you can hear me. I switched to a new computer. Those were great answers, and this will definitely be used when we go back to the Maryland legislature next year. I have a couple more questions that were on my original list, but I think we can answer a couple audience questions first and I wrote them down. We had a question from Mary about what I assume is Robinson Township case, and I believe Rabbi Cardin answered that. If your question was not sufficiently answered, Mary, please send me a message and I will re-ask it. We had a question about grandfathering in bad permitting and sites of pollution. Paula, do you want to unmute briefly and ask your question more specifically?
Sure. I'm sorry, I've got a background music, but yeah, what about, like, we have Bresco, which is in Baltimore City, which is a trash to energy, and polluting that area for years and years and years. And they can probably prove it by the number of asthma and cancer cases there. Is that something that would be covered by an environmental rights amendment? Can a organization bring a suit against that, because it's really impacting negatively the surrounding community?
Roger, if you don't mind, I'm going to take first crack at that, because the Environmental Rights Amendment doesn't allow citizens or people in the community to sue private actors. But what it does do is allow citizens to push, it gives citizens a new tool for pushing their state government to reevaluate the standards by which permits are issued and the way that enforcement occurs. And I think that's where a tremendous amount of its power is in pushing government to rethink that balance that it makes between economic benefit and environmental protection, by putting a real thumb on the scale for protecting the health of communities, protecting the health of individuals, protecting the environment itself. And so that's where I see this having the biggest impact for existing polluters, is that the standards may be ratcheting up for them, and may ratchet up significantly, so that they, to stay in business, must do a much better job in terms of their environmental stewardship.
I think that's a great answer. Roger, did you want to add anything?
No, I think that Rebecca and the New York experience will implicate that to some larger extent the Montana experience, where we've had this in place for the last 50 years. I would say that one distinction with the Montana provision is that, as I mentioned in quoting from Article 9, the Article 9 provision explicitly creates not only a right but a responsibility. Also, I think that that's important in terms of an important part of our paradigm. And it's something to kind of consider in the framework of other jurisdictions moving forward. But it, as I mentioned, our Article 9 provision states the state and each person shall maintain and improve a clean and healthful environment. So we have not only this fundamental inalienable right, but we have a corresponding responsibility. So it is actually considered to be kind of the balance point. It's not just that I have a right to a clean and healthful environment. I also have an individual, private, personal responsibility under our Constitution. And so the way that our Supreme Court has construed that is that it does come into play. For instance, in the case that I'll just cite is Cape France Enterprises versus the Estate of Peed, a 2001 Montana Supreme Court case where there was a buy-sell between two private parties, and the purchaser wanted to enforce the buy-sell agreement, but in the meanwhile, the Department of Environmental Quality had informed the seller that there was a plume from a dry cleaning facility that was created a huge plume in the area, and that in order to fulfill the buy-sell, they had to demonstrate that this tract of land had waters that could service the proposed subdivision. And in the meanwhile, this plume had been identified under it. And so the seller argued that, well, performance of this private contract was impossible because it would contaminate or could potentially contaminate the water table. And the Montana Supreme Court held that indeed that's right, that the clean and healthful provisions apply to private citizens and private property. Quote, the text of Article 9, Section 1 applies the protection and mandates of this provision to private action, and thus private parties as well. The duty to maintain a clean and healthful environment extends to the state, to state officials, to private parties. So I think that's an important provision of the Montana experience that that not all states have. And then I would also say that that once again, I do think that the doctrine of constitutional avoidance that we spoke of before, normally because of impossibility, you could abrogate the performance of a contract, but here they actually had, when they went through all of the the standard contract defenses, they kind of had to get all the way down to impossibility based on violation of the Montana Constitution. So that is kind of an example of how the Montana plays out. If you can avoid constitutional involvement in a particular decision, the courts will. When they can't, they must, as a matter of their judicial responsibility, construe what the Constitution means in that circumstance.
Thank you. And I think if anybody is very interested in this very specific topic, Roger has a recent paper in the Public Land and Resources Law Review, volume 45, that is also very on point. We have another question. Looks like it's for Rebecca. Now that New York has an environmental rights amendment, whose job is it to follow through on addressing cumulative impacts? Is this a charge for the legislature or a charge for state agencies and local governments?
Well, the New York legislature passed a cumulative impacts bill that is sitting on the governor's desk. I am still hopeful that she's going to sign it into law. We'll see what happens. But one of the things that this amendment does is that it puts duties on all government actors. It's not, I've been talking a lot about the DEC because they're the main permitting agency, but they're not the only permitting agency. This is going to require government actors across the state, local governments as well, to rethink the way they do things. And in fact, we've been having a bunch of meetings with town councils about what does this mean for you, and how should and could you change what you're doing in light of the constitutional amendment. Somebody I saw asked if there are any decisions from the court. I just want to be clear, like, we've had this for 11 months. There are no decisions yet. The Fresh Air for the East Side case is the furthest along because they had a hearing on a motion to dismiss. I'm expecting a decision pretty soon, but we don't have any decisions yet about this. We do see one of the things that happened is that the DEC rejected an application for a power plant that had been decommissioned to come back online to mine cryptocurrency. And the decision from the DEC reflected a whole bunch of state priorities, including this new amendment. One thing I wanted to say is, as you in Maryland are thinking about how to draft a constitutional amendment, I think what Roger said is really important. The New York amendment has the advantage of clarity and simplicity, but what it doesn't have, that Montana has and that Pennsylvania has, is an explicit public trust component. And personally, I wish the New York constitutional amendment did, for what it's worth. And I also just want to say, I saw there was a question from, I think it was from Mary, about rights of nature. These are not mutually exclusive approaches to take, right? A human right to a healthy environment, a constitutional right to a healthy environment, and rights of nature are not, they're two paths to go down. It's not an either or, you can have both.
That is a great response. I have one direct message that I'm going to mix with what was our intended last question, and I'll give you both a chance to speak briefly before we all sign off. A common question raised by opponents is that this is risky, it may have unintended consequences, and that we should wait. In addition to this question, I would like to ask you why we should do this now, and in addition to the recommendations that Rebecca just made, do you have further recommendations for states like Maryland who are trying to enact an environmental rights amendment? We can start with Rebecca.
So this is risky and might have unintended consequences. It's amazing how people are not concerned that manufacturing chemical products with no pre-clearance, about spewing carbon dioxide and particulate matters and SOx and NOx into our environment is not risky and likely to have unintended consequences. It's only when we want to protect the environment that that argument raises, that gets any traction. I mean, it seems very clear to me that what's risky is business as usual. What's risky is not recognizing that we are destroying the planet and we're killing ourselves and our children and their children, and we have to do something differently. This is one way to do it differently. It's not the only way to do it differently. And, you know, in New York, we're saying, great, we have this, now let's make it mean something. And that's really where the campaign is, because the same people who told us that this is risky and will have unintended consequences and we can't dare do it, also told us at the same time, well, you know, this won't really do anything. It's just pro forma. And what I say to everybody that I talk to is, this law will mean what we make it mean. So let's make it mean something real and important and transformative for New York, and a model for other states that also are looking for real transformative change.
Thank you. Roger?
Yeah, I love that phrase, Rebecca, that you have, that it really, to some large extent, will depend on what you make of it. And that is, you know, indeed the case in Montana. I know when I was in law school 40 years ago, I helped to organize our first law school class seminar on the state constitution. And in that class, we imagined how this constitutional provision on clean and healthful environment could be implemented in the courts. And so it's been a great pleasure of mine over the ensuing decades to help implement these provisions through judicial decisions and in some instances administrative. But it's not a answer to all of the environmental challenges that we face. It's another and an important additional component to the struggle to achieve environmental quality and environmental justice. But it will also take really strategic and thoughtful use and implementation. So I think that's that's certainly the lesson that we've experienced here in Montana, which of course is quite a different political culture than that you're experiencing in New York or Maryland. But I think that our most successful cases have been those that have challenged, as successfully challenged as unconstitutional regulations from our permitting agencies, our Department of Environmental Quality, and also statutes that have prohibited the effective remediation or providing obstructed remedial remedies that would assist in the implementation of our constitutional rights to a clean and healthful environment. Those instances have been, clear. It's a good fit with our traditional judicial review paradigm, and they have helped to inform our political culture. But we also have to recognize that there's a lot going on in the country, and indeed a lot going on in our increasingly red state. So we also have the task on our hand in terms of not just litigating, but also preserving these constitutional rights. So I would certainly encourage the Maryland effort. It adds, I think, another dimension and an important dimension, especially given the great tradition of the Maryland Constitution, which I have had the opportunity over the last year to study just a bit. And so I encourage you. I think it's important. It's worthy of your efforts. And once achieved, you'll also have the task, as Rebecca is engaging in, and as I've attempted to engage in over the years, of implementing it. So thank you all for your questions, and good luck to the Maryland folks in their very worthy effort.
Well, let me thank Joe for moderating this wonderfully. Let me thank Rebecca and Roger for your thoughtful, inspiring, and encouraging messages. It does get disconcerting sometimes when we come up against these headwinds, and so knowing that there's success out there and knowing that there are people who are rooting for us and who have our backs is really quite reassuring. So we thank you so much. We thank all of you for joining us. You will be receiving a recording of this, and we continue to do the good fight, and along with you, we will one day win this here in Maryland as well. And we will be watching Maryland, and we'll be watching Montana and New York too for your development. So let's keep in touch. Okay. Thank you so very much. Take care, everybody.